Lesson: types of breaches. Breach of contract is a fundamental concept in contract law that occurs when one party fails to fulfill their obligations as stipulated in the contract. Understanding the various types of breaches is essential for professionals aiming to become certified contract law specialists, as it enables them to identify, address, and resolve these issues effectively. There are several types of breaches, each with distinct characteristics and implications. These include material breaches, minor breaches, anticipatory breaches, and actual breaches. By comprehensively examining these breaches, professionals can enhance their proficiency in managing contractual disputes and protecting their clients' interests. A material breach is a significant violation that undermines the very essence of the contract, thereby excusing the non-breaching party from their contractual obligations. This type of breach is often considered a serious failure to perform that affects the outcome of the contract, rendering it impossible to fulfill its purpose. For instance, in a construction contract where a builder uses substandard materials that compromise the structural integrity of a building, the breach is material because it fundamentally deviates from the agreed-upon terms. To determine whether a breach is material, professionals can utilize the five-factor test established in the Restatement of Contracts, which assesses the extent of harm caused, the ability to compensate the non-breaching party adequately, the likelihood of cure, and the breaching party's behavior. By applying this framework, professionals can systematically evaluate the severity of a breach and advise their clients on the appropriate course of action. Minor breaches, also known as partial breaches, occur when a party fails to perform a small or inconsequential part of the contract. Unlike material breaches, minor breaches do not excuse the non-breaching party from their obligations, but may entitle them to damages. For example, if a supplier delivers goods slightly later than agreed, but the delay does not significantly affect the buyer's operations, it constitutes a minor breach. Professionals can employ practical tools, such as a breach impact analysis, to assess the consequences of minor breaches. This analysis involves evaluating the breach's impact on contractual performance, financial implications, and potential remedies. By conducting a breach impact analysis, professionals can provide actionable insights to their clients, enabling them to make informed decisions about pursuing legal remedies or negotiating settlements. Anticipatory breach, or anticipatory repudiation, arises when one party unequivocally indicates that they will not fulfill their contractual obligations before the performance is due. This type of breach allows the non-breaching party to take immediate legal action without waiting for the actual breach to occur. For instance, if a service provider informs a client that they will not complete a project as contracted, the client can treat it as an anticipatory breach and seek damages or terminate the contract. To address anticipatory breaches, professionals can apply the doctrine of anticipatory repudiation, which provides a framework for determining whether a party's conduct constitutes a clear refusal to perform. This framework involves analyzing the party's statements, actions, and circumstances to establish intent. By leveraging this doctrine, professionals can guide their clients in taking preemptive measures to mitigate risks and minimize potential losses. Actual breaches occur when one party fails to perform their contractual obligations by the due date. Unlike anticipatory breaches, actual breaches happen at the time performance is required, making the breach evident and actionable. For example, if a contractor fails to complete a renovation project by the agreed deadline, it constitutes an actual breach. Professionals can utilize a performance checklist to systematically assess whether a breach is actual. This checklist includes verifying contractual terms, evaluating performance against expectations, and documenting any deviations. By employing a performance checklist, professionals can provide a structured approach to identifying actual breaches and advising their clients on pursuing remedies, such as seeking damages or specific performance. Case studies and real-world examples illustrate the practical application of these breach types and the effectiveness of the tools and frameworks discussed. The landmark case of Jacob and Young's, Inc. v. Kent, provides insight into the concept of substantial performance and its relation to breaches. In this case, the court ruled that a minor breach occurred when the contractor used a different brand of piping than specified, but the deviation did not significantly affect the building's value. The court's decision emphasized the importance of evaluating breaches based on their materiality and impact, reinforcing the need for professionals to apply a holistic approach when addressing contractual disputes. Statistics on breach of contract cases further underscore the prevalence and significance of understanding breach types. According to a study by the American Bar Association, breach of contract claims accounted for approximately 60% of all civil litigation cases in 2020, highlighting the importance of equipping professionals with the knowledge and tools to navigate these disputes effectively. By integrating practical tools such as breach impact analysis, performance checklists, and the anticipatory repudiation doctrine, professionals can enhance their ability to address real-world challenges and provide comprehensive solutions to their clients. In conclusion, a thorough understanding of the various types of breaches is essential for professionals seeking to become certified contract law specialists. Material breaches, minor breaches, anticipatory breaches, and actual breaches each present unique challenges and require distinct approaches to resolution. By applying practical tools and frameworks such as the five-factor test, breach impact analysis, the doctrine of anticipatory repudiation, and performance checklists, professionals can effectively identify, assess, and address breaches, ultimately enhancing their proficiency in contract law. The integration of case studies and statistics further reinforces the importance of these concepts and their practical application in real-world scenarios. By mastering these tools and strategies, professionals can provide valuable insights and solutions to their clients, ensuring the protection of their contractual rights and interests.